S23A0054, Chad Haufler versus the state, Andrew Fleischman for appellant, Wright Barksdale for appellant.
Good morning, Mr. Fleischman. You may proceed.
May it please the court, my name is Andrew Fleischman, and I'd like to talk just about the instructional error issue in this case here today, which is pretty straightforward. There's really two theories of the case. The state's theory is that the defendant and the victim got very drunk, they got into a fight. The defendant beat the victim really badly. He falls down in sort of a pool of his own blood. He crawls over to the couch, and then he's shot in the head. The defense theory is that the shot happens in the kitchen while the two men are still struggling upright. There's blood spatter on the wall there. He walks by a window, aspirates some blood there, falls down on the couch after he's been shot. That's really the two theories of the case that we go forward here on. So there were three requests for lesser inclusions in this case that the trial court denied. They were for involuntary manslaughter based on reckless conduct, pointing a weapon, and for just plain old negligence, like in MacGyver v. State. First, I want to talk about...
Let me ask you a question. I believe it's the state argues that as to the latter, it's plain error because you had preserved it. What's your response to that?
On page 976 of the transcript, the trial court specifically, first off, those requests were made, and on 976 of the transcript, the trial court specifically says, no further exception needs to be made. You've done it. Don't object again. So for that reason, those issues are preserved. So as far as pointing a weapon is concerned, the evidence is pretty straightforward. The defendant pointed a weapon. And really the only question is this an all or nothing case where it's either the full-on malice, murder, ag assault or nothing? And no, it's not. Because the evidence, the circumstantial evidence in the record supports that the victim was not aware of the weapon at the time it was pointed at him. Why is that? Because the state's theory of the case was that he was beaten really badly with a popcorn kettle and was lying in a pool of his own blood before he collapsed on a couch when he was shot. If you believe the state's version of events, then yes, there is strong circumstantial evidence that the victim was not aware of the gun at the time it was pointed at him, in which case that would support a pointing a weapon charge. As far as the reckless conduct charge goes, getting very intoxicated and handling a weapon, even if it's to go handle a dispute with somebody you're having a fight with, that can also be reckless conduct because it consciously disregards the substantial and unjustifiable risk that something will go wrong. Now, that is support.
What is the evidence actually in the record that Mr. Haufler recklessly or negligently handled a weapon versus what he actually said multiple times that he went upstairs and got the gun and came downstairs to the basement and shot the victim?
And exclude the statements by the doctors who kind of make some assertions.
Well, it's harder without the statements of the doctors, but I'll say, what's the evidence? I mean, the fact of the matter is there is evidence that there was an ongoing struggle at the time that the shot went off. The lack of sparing on the man's right hand. The sparing on the man's right hand, I mean, there's no blood there, which indicate he was holding the weapon. So we don't know at what point in the altercation the gun came down. And even if you agree that he said, I shot the guy, that doesn't mean that he shot him on purpose. He didn't say, with malicious intent.
So let's explore this a little bit.
Mm-hmm.
Often when we see errors that are enumerated on instructional charges, someone will say there was slight evidence, very low standard, there was slight evidence of this thing that the trial court should have instructed. But often when that happens, you have someone saying, for example, I did this in self-defense, even if the person also said, I totally did this on purpose. And if the guy says I did it in self-defense, even if it's self-serving, that's slight evidence you're supposed to give the charge. Sometimes you'll have somebody else who testifies. You have direct evidence. Are you allowed to have an expert testify to establish slight evidence when the evidence is really only an expert saying not, it is my expert opinion that this happened, but rather, I can create a scenario under which these hypothetical things could have happened? Can that actually establish slight evidence?
Yes, and the reason why is
there a case where we've said that?
No, but let me go on a little
Thanks
further.
for your honesty.
What I would say is that circumstantial evidence is evidence, and all that an expert is doing...
Is hypothetical evidence always circumstantial evidence? Is the admission that one can construct a hypothetical scenario actually circumstantial evidence?
Well, not only is it reasonable, but the instruction says you have to exclude reasonable alternative hypotheses. The word hypothetical is in the instruction.
When would you not be able to do that? Like, based upon what you're saying, every case we get like this, someone could always bring an expert in to give a theory, and that would be enough to give the lesser charge?
First off, I'm going to generously assume defendants won't bring in somebody to like lie or make stuff up. I mean, what they'll do is they'll bring in an expert who will look at the circumstantial evidence and say, for instance, oh, I looked at the black box data on this car, and it could support the idea that he didn't intend to press down on the accelerator. Or I've looked at the makeup of this gun, and it's possible it's an accidental discharge. So what you're saying is like, circumstantial evidence, of course, has to be enough, because the whole point of a circumstantial evidence.
But the problem is, I think sometimes it's different when circumstantial evidence is data or information that can point to whether something did happen or something didn't happen. It's much harder when you're talking about subjective intent. And it seems like there might be a difference when an expert is not providing an expert opinion on what happened, but opining on a range of things that could happen, even though those things have to be subjective in the mind of a person that is not him or herself testifying about that.
Well, the thing that the expert testified could have happened, right, was that they were struggling over the gun upright in the kitchen. The gun goes off while the victim is holding it. That's her testimony, right? She said that's possible. And in fact, it's supported by that evidence of the lack of sparing on his hand.
So
But counsel, sorry.
it seems to me that you probably have the better of the argument that there was, in fact, slight evidence to warrant the giving of the instruction. But that slight evidence, because of its hypothetical nature, was very slight. And so you have to show not only that the instruction should have been given, but that failure to give it made a difference.
What's interesting
So
about
where's the harm?
I think what's interesting about this case is the total lack of motive for these men to get into a fight or for there to be a murder. They are good friends, and not only good friends, such good friends that the defendant calls the victim and says, I'm having marital problems, and the victim flies over. They go drinking and fishing for the next couple of days. And in the MacGyver case, the good relationship between MacGyver and his wife was a factor in whether he intended to kill her. Not only did you have the fact that they had a good relationship, you also had the fact that they were good character evidence witnesses who
So, I
testified.
mean, look, I agree with you that the case is confounding. I mean, it's you read it, and we didn't try the case, but you read the record and it's confusing. It doesn't make complete sense why what happened. But you still have to overcome things like a downward angle, that someone testifying that the gun was at a downward angle. That would undercut a lot of the theories that the experts you offered. So,
And a number of statements by the defendant making clear that it was not some sort of accident.
Well, Your Honor, I take the record as I have it. And what I would say is that the best evidence that goes to support the lack of intent is the lack of motive. The fact that these are two men who mostly got along, the fact that the victim himself had had also been drinking heavily, had Lewy body dementia, the possibility of Parkinson's, there was some evidence to support that there was a struggle, certainly, in the record, and that was supported by Dr.
Fleischman,
Combs.
The appellant states he goes upstairs to get the gun and shoots him multiple times.
That's right.
It's not pointing the pistol and it goes off once. There's multiple shots after he intentionally goes and gets the gun,
Well, Your Honor,
according to him.
right. I mean, there was also Dr. Kim Fromm, who testified in this case to the confabulation that can occur when someone is very intoxicated. Sometimes people who are very drunk just make stuff up. And in this case, the defendant specifically told police there were 3 intruders at his house. He shot one of them. Then he said some other guy's name. He's extremely weird and agitated in the video, if you'll watch it. And the cops at the scene are saying, this guy is off the map. We don't know what's going on with him. So, yes, the defendant made a lot of statements, but the defense did bring in evidence to explain why those statements could be mistaken or confabulated.
and I think that's the hard part for your case, because if you're assuming that there was a problem with the instruction, and you're looking at harmless error, the jury's allowed to infer so much from the many statements and the demeanor.
100%. That's true. But that demeanor doesn't support just one alternate hypothesis. The fact that he's extremely agitated and freaked out could just as easily support an accident as deliberate intent, right? Sometimes, if you do something terrible by mistake, you might say crazy things. In fact, in the MacGyver case, a huge part of the state's case was that MacGyver made numerous statements at the hospital saying, oh, I know how these things go down. I'm worried about what's going to happen. He made up some alternate versions of the fact that didn't make sense. I mean, the fact of the matter is that people who are innocent often still do and say things that make them seem guilty.
There was no evidence in the MacGyver case that MacGyver had admitted he purposely shot his wife, correct?
No.
You stated earlier that there was no evidence here that this defendant purposely shot the victim.
I'm sorry if I said that, because that's not true.
If you watch his video of his sitting in the back of the patrol car, he clearly says, I shot the person.
Well, he
Now,
does.
He confuses who he shot until later in the video when it's fairly clear he shot this victim.
I would say
Where
that
he's almost laughing about it.
I mean, that's true. That's a fair account of how he says it.
Wouldn't it also be fair, I mean, when you say you shot somebody, in the sense that sometimes we'll also say, you know, you hear a car accident, I hit somebody. That doesn't mean it was my purpose to hit them, right?
Right.
And when we talk about all the inferences that jurors can and do make or are allowed to make, if I read your argument, what you're really saying is that a jury who believed the evidence required accountability was left without an intermediate option.
That's correct, Your Honor. There was no voluntary manslaughter option. There was no involuntary manslaughter option. The state does say in its brief that there was an involuntary option offered. I think that might have been mistaken. I didn't see that when I checked back on the record. So the jury was really left with all or nothing, and that's kind of unsatisfying in a case where, again, it's just a mess.
Counsel, let me go back to whether there was slight evidence even of some sort of reckless conduct or criminal negligence. I mean, what are you relying on for that? Is it the testimony of the experts, Dr. Fromm and Dr. Collins? Because I've read that testimony. I don't see where they actually even say that they can't opine, because they weren't there, that Mr. Haufler recklessly handled the gun or negligently handled the gun. I mean, we have an expert who's a forensic pathologist talk about the cause of death, and we have an expert on BAC levels and blackouts as a result of drinking. I mean, where's your expert on how the gun was being handled?
You don't need an expert to say it's a bad idea to get very drunk and handle firearms. And in fact, we have a misdemeanor in Georgia that specifically says you may not discharge a weapon while you are intoxicated above a .08. So, for instance, if the defendant had shot the victim by spitting the gun on his finger, that would be a negligent homicide. If he was intoxicated, that would be more evidence of that negligent homicide, right? The fact that he was spitting it and he was drunk would be additional evidence of negligence that the state would bring in.
But don't you have to bring in some evidence that he was negligently doing something versus speculation, oh, he can't remember, so we kind of assume that he was negligently handling it?
So let's assume we go with the defense theory that's supported by Dr. Collins, and he's super drunk, and at some point in this fight, he runs upstairs and gets a gun, and they struggle over it. And the idea of getting the gun, of bringing that into the situation, not knowing what's going to happen next, consciously disregarded the substantial unjustifiable risk that a shooting would occur.
What is the evidence they struggled over the gun?
The evidence of the struggle over the gun is Dr. Collins' testimony. That the lack of sparing on the hand, the fact that there's high-velocity impact spattered by the kitchen at an angle that would suggest that that's where the shot occurred, the fact that there's aspirated blood on the window where the victim would have walked past on his way to the couch after being shot. You can tell it's aspirated because there's bubbles in the blood. Those are the things that support that there was a struggle at the time. And that's a circumstantial evidence.
But she wasn't qualified as an expert on blood spatter. She was specifically qualified only to opine on the cause of death. I mean, she's a doctor. She's a forensic pathologist, not a crime scene specialist. She says that.
It's true, but the blood spatter evidence about the high-velocity impact spatter came in, I believe, before the state's objection to her qualification to testify to that. I believe it came in without objection. I could be mistaken.
I get your point that there might have been evidence, slight or otherwise, of a struggle. I mean, but struggling over a gun and struggling with this headlock argument that he makes repeatedly throughout his interview, I'm trying to find the evidence that connects the two, struggle versus struggle over a gun. And your suggestion that the only evidence of a struggle over a gun is that there was blood splatter in the kitchen area. And
the lack of blood on his right hand, yeah. Basically, Dr. Collins' testimony, and also that the 20-degree angle would be consistent. She testified to that as well. So that's the evidence in the record that supports it, Your Honor.
But the evidence is also that he only goes to get the gun after the struggle, correct?
Your Honor, I honestly don't know if we prove that one way or the other. I don't know that it's established beyond all that he only goes up and gets the gun after he's beaten the guy and he's down on the ground, or whether there is
Well, I think
intermission.
Justice Colvin's point is if we're going to credit what the experts are hypothesizing about, we can at least credit the defendant's own statements.
That's true.
Insofar as the jury has to evaluate the veracity of those claims.
Yeah, I mean, he certainly says he goes up and gets the gun. I am not sure that he ever says at what point that occurs.
There is evidence from which the jury could have concluded that while sitting in the back of the police car, he said he left that headlock, flipped the victim. Then he was asked by, I believe, the assistant coroner, where was the gun? And he said, I went upstairs and got it. So in that sequence, it could be argued that during that struggle, fight. He left the fight to go get the gun and came back.
Yeah. So,
Did he ever, during the course of the officer's conversations with him while sitting in the back of the car, say there was a struggle over a gun?
no. But the standard required here is slight evidence, and what the state must show is that it's highly probable it did not contribute to the verdict.
Can I just ask real quickly, going back to the sort of theories you have for which misdemeanor can support the involuntary manslaughter charge? Could you just tell me, in your view, sort of what you view as kind of the stronger argument for which there was sort of slight evidence to support, or do they sort of stand and fall together?
I'd say they stand pretty much all together. I'd say recklessness and negligence is just the negligence and recklessness of retrieving a firearm while you're very intoxicated, and the risk of what can happen when you want to go handle guns while you're very drunk. And courts have held that we have a law, in fact, that says it's negligent to discharge a weapon while you're intoxicated. So it's the state's burden to show it's highly probable this did not affect the outcome. And given the good character evidence presented about the defendant, given the relationship he had with the victim, I believe that the state cannot meet that burden. I reserve the rest of my time. Thank you.
Thank you, Mr. Fleischman. Ms. Barksdale.
Good morning. My name is T. Wright Barksdale. I'm the district attorney for the Okmulgee Judicial Circuit, and I tried this case along with my chief ADA, Allie Malden. I want to start with the in-car camera, where the appellee says, "I hope this is recorded because I want this taken down. He had me in a chokehold. I couldn't breathe. I was ready to pass out. I freed myself. I shot him. I think I grabbed him in a chokehold, and then I went and got my gun." I've watched this video over and over and over again, and I've counted 13 times, at least 13 times, where the appellee at some point says, "I shot him. I shot him." When you compare that to the crime scene testimony from Special Agent Brian Hargrove with the GBI, it paints a very, very dark picture about what happened in that basement in August of 2018. What Brian Hargrove testified to based on the blood evidence that was across the room, and I'm sure you've seen the photos as well, in conjunction with the blood evidence that was on Mark Demos's face. What Brian Hargrove testified was that he was beaten about the face, most likely with that popcorn kettle, and that he laid there long enough for the blood that was running out of his face to actually dry.
So, Counselor, is the argument that you're embarking on here just that the evidence was overwhelming so that if there was any error, it was a harmless error?
Your Honor, I believe, based off of the evidence in the case law that's been provided, that this charge, there was no evidence because the defendant intended to do this. This isn't MacGyver
But what
sitting in
about
the...
the evidence from the experts? I mean, if you take it together, that from Dr. Fromm, that Mr. Haufler blacked out, so he was, making up a bunch of this stuff. And then Dr. Collins did testify that it could have been a struggle, that there was no blood on the palm of the hand indicating that the victim was holding the gun at the time of the shooting. Why isn't that slight evidence that there was some sort of reckless or negligent handling of the gun?
And with all due respect, it sounds like you're very familiar with her testimony. I understand that it may be very, very slight, but I'm sure you've read her testimony and some of the things that she testified to.
Are you conceding it's slight? Because if it's slight, there was supposed to be an instruction.
No, Your Honor. I do not believe that. When somebody has said 13 times...
That's not
No,
the
no, no.
standard. The standard's not weighing which one is more credible. That's what you do when you're trying the case and the jury gets to decide. But when there's a legal question about whether the instruction was supposed to be provided, if there's even slight evidence, the instruction was supposed to be provided.
I think when you read her testimony, that transcript, I don't believe, if you go back and look at the questions that I asked her about what she was saying, she equivocated several times.
Well,
But if you do...
Is equivocation, I mean, even if there's equivocation, if there was evidence, however slight, it's still evidence. If it's evidence that is rebutted, if it's evidence that's overwhelmingly outweighed, it is still evidence.
If I'm not going to concede that there was evidence, even slight, in this case, however, if this court were to say, you know what, right, we believe that there was slight evidence, then I would say it was harmless that this charge wasn't. What we have is a man that was beaten so badly that the medical examiner for the GBI said there were 24 documented injuries to his face.
I don't think being beaten that badly answers the question of well, I guess if you're assuming that there was an error for purposes of argument, then maybe it's a different story, but.
And that's where I was going, Your Honor, is that based on 24 documented injuries and a stainless steel popcorn kettle actually being dented in, and the evidence taken as a whole, and then what's critically important here is that Mark Demos was an ill man. He was sick, but he was also bigger than the appellee. And there was a 20-degree angle on this entry wound. And it wasn't, shot in the leg. It wasn't.
Counsel, can we go back to sort of the colloquy that Justice Bethel had with my friend on the other side about harmless error, right? So if you assume slight evidence, however slight, about sort of lack of intent and the various things that the experts say, so you're at harmless error, you have that slight evidence, and the argument, as I understand it, is you have this slight evidence that he did it without intent and that there's involuntary manslaughter, but if the jury believes that slight evidence, there's nothing for them to do. There's no instruction, there's no lesser included involuntary manslaughter, so they're choosing between intentional, he did it, or nothing, this sort of all or nothing question. Can you speak to that and tell me why that doesn't sort of make your harmless error argument a little bit harder?
Well, I think for one thing, when you look at the MacGyver case and the decision that was rendered in that case, the court points out about how the state's case was not strong. The state's case was weak. In this case, and I do want to, and I apologize, but I do want to go back to, this man was shot in the right below the left eye. And when you take all of this in, if the court is to say that it wasn't harmless error, if we're going to go there, then as some of the justices have said, we are now at a very slippery slope of defense attorneys can come in, hire an expert, say and hypothesize whatever they want to, and now we're going to charge voluntary manslaughter on just about every murder case. There are cases out there where that would be appropriate.
Well, that sounds like a little bit more of a policy answer than the legal answer. But I mean, I guess the legal answer that I could draw from that would be that you think that kind of evidence in this case is so slight that it wasn't going to move a jury to pick the sort of middle option. I mean, is that the argument that you have to make for harmless error?
Yes, and I also want to point out, I believe the jury was out 4 days in MacGyver. The jury was technically out about 21 minutes on this case. The reason it took an hour was because we had to move them from Festival Hall because we tried this during COVID, and they deliberated at the courthouse. It took longer for us to get them the evidence than it did for them to make a decision. I just go back to when we look at this, and it's every case that you try, you look back. As I read that transcript, there's things that I look at and go, I could have done this a little different. I could have said this a little different. This case, at the end of the day, and we'll never know why, but this man was unmercifully beaten, laid there for some period of time, long enough for the blood to dry on his face, and then was shot. And I'll use the appellee's words, point blank. Shot in the face.
While we're on the subject of harmless error.
Yes, sir.
You make in your brief the argument, you argue that you satisfy the standard of preserved non-constitutional error, highly probable it did not contribute to the verdict. But there's also an argument that the appellant actually withdrew their request for this instruction, and so it should be reviewed only for plain error. What is your position on that? Recognizing that Mr. Fleischman's position was the initial objection, the judge said you can have that, essentially.
Yeah, we'll stand on the brief on that. When you read that, I can understand where he's coming from on that. So I'll just stand on the brief and the argument we made there. But the large message that I want to leave this court with this morning is yes, there are going to be cases that come before the court where this argument may carry some weight. But this case,
Which argument?
that a voluntary manslaughter charge should have been given. But this is not the case. There are cases out there.
Counsel, that is such an odd argument to hear from the state's attorney. Let me see if I'm clear. Do you agree or disagree that our law in this state, case law in this state, requires, mandates a charge on a lesser included if there is slight evidence to support it?
I do agree with that, Your
Okay,
Honor.
so it's not just that there'll be some cases, it's every case where there's slight evidence the charge should be given. There's some question as to, on appellate review, whether or not that's harmful or not, but you're not arguing that we have to pick and choose when we
No,
decide
Your
that
Honor,
there's slight
absolutely
evidence whether
not.
to give a charge. Okay, thank you.
And I do believe that in MacGyver, in determining slight evidence requires consideration of all the evidence of the defendant's intent based on the circumstances surrounding the fatal act in question. The evidence necessary to justify a jury charge need only be enough to enable the trier of fact to carry on a legitimate process of reasoning. And that really stuck with me, a legitimate process of reasoning given the facts of this case. I'll be happy to answer any other questions that you have, and I appreciate the court's time.
There don't appear to be any. Thank you.
Thank you.
Appreciate it, counsel. Mr. Fleischman, you had some time left, a little over 4 minutes.
Thank you, Your Honor. The long and the short of it is, I believe the circumstantial evidence in this case does support the charges of reckless conduct, pointing a gun, and negligence. And there is slight evidence in the record. So the only question is whether it's highly probable. And while the state does say that the jury deliberated for only a short time, when the options are all or nothing, that's very easy to do. Something happened here.
If we agree with your argument that there was slight evidence in this case due to the fact that Mr. Haufler was drunk, there was some expert testimony that he may have blacked out, and there was some evidence of a struggle.
Mm-hmm.
So you're saying in any of those situations, in any case, that involuntary manslaughter charge has to be given?
If an involuntary manslaughter charge is requested and there's that kind of evidence, then yes. But as
Just because someone's drunk and there's a struggle over a gun?
does that support that they didn't deliberately shoot the person, or if they brought a gun to a struggle recklessly? Then yes, that should be given. And we trust our juries to sort out those sorts of things when there's slight evidence and to figure out what happened to the best of their ability. But here, this jury did not get that chance. They were not trusted to make that choice. And that fundamentally is the problem. The jury should have been given the full range of justice, of choices, so they could enact justice as they saw fit. And the judge should not have kept them from that when there was evidence to support these lesser charges. Thank you.
Thank you, Mr. Fleischman. Thank you, Mr. Barksdale. Appreciate the arguments and the briefing in the case. We will have you a decision as soon as possible.